Did you know that in the state of California, a driver could be in trouble for leaving the scene of the accident, even if the accident is ultimately determined to not be that driver's fault? Please join my associate Alana Wilson and myself in this panel discussion about the many duties and responsibilities of California drivers and our helpful list of tips and tricks and suggestions for how to stay out of trouble if you or someone you know or care about have been involved in a car accident, unfortunately made the decision to leave the scene, or are now facing the danger of being investigated or prosecuted for a hit and run. Hello, my name is William Pernik. I'm a criminal defense attorney and a certified specialist in criminal law by the State Bar of California.
And my name is Alana Wilson. I'm an associate attorney at Williams Firm.
Alana and I do a lot of cases involving car accidents and hit and runs. And it's always very frustrating for us to see good people who don't have criminal records finding themselves oftentimes in serious trouble because of basic misunderstanding of California law or the many duties that California law imposes on everyone who decides to drive a car or a motorcycle on its many streets, roads, and highways. I think the first example that we see that's always very frustrating to us as criminal defense lawyers is the scenario where a person simply does not understand what their legal obligations are. It's really common, a lot more common than most folks realize, because in this area, like many others, California law is very nuanced, it's complicated, it requires a number of things of anybody who's involved in an accident that could result in damage or bodily injury, and a lot of folks are really not clear on what their duties are.
Another common example is a miscommunication between the drivers. So perhaps you pull off the road thinking you're ready to give your insurance to the other driver, and they drive off thinking you've already left the scene. Right,
and then what we see a lot of our clients do, which is totally illegal, unfortunately, but folks figure, well, no harm, no foul. The other person took off. I'm good to go. Not so much, because under California law, if you are involved in an accident that resulted in damage, if you are involved in an accident that resulted in somebody getting injured, you still have to report it, whether the other person wants to have it reported or not, just like any other crime, because there are other crimes where, a victim of a crime perhaps may not want to report it for a variety of reasons. Maybe they're undocumented, maybe they're embarrassed. For whatever reason, they don't want to cooperate with law enforcement. That doesn't mean there's not a criminal liability. And so in hit and run scenarios, one has to be very careful, because otherwise that criminal liability may well attach. The third example I would like to bring up is a fairly common scenario. It does not happen when there is obviously a lot of damage. So if you are involved in a head-on collision, it's not going to happen. But sometimes in these rear-ending at the stop sign or red light type of accidents, you may be in the situation where the damage is so slight that you don't realize there is damage. And you leave the scene of the accident thinking, there's no damage, or the damage is so minimal, no one's going to worry about that. And that may expose you to liability for hit and run.
Mm-hmm. Absolutely. Another common scenario, too, is if somebody is unable to report due to a fear of danger.
Oh, that's a good one.
Yeah, perhaps the other driver that they're dealing with may have a demeanor that scares them, or perhaps they've had past experiences with strangers that make them nervous to report due to their fear that this other person may hurt them.
I think that's a really good example. And the first point that you brought up, we've had a couple of cases that you and I have handled where, our clients are involved in some sort of an accident, they pull over, and the other driver just goes completely nuts, starts cussing, yelling, threatening. Sometimes this happens late at night and here on the outskirts of San Jose, or perhaps if you are somewhere in the middle of nowhere, you may be afraid of the other driver. So you figure, well, they acted this way, I'm afraid, I'm just going to take off. Does that clear you from hit and run liability? Not necessarily. Your next steps really matter, and we're going to cover those. Another related topic to being unable to report due to danger, there is also a scenario where folks are not able to report because it's not clear who do they have to report to. And to me, that relates to lack of general understanding of what the duties are in a hit and run scenario, because in the rural area, for example, if you're driving somewhere in Gilroy and you go off road and you end up driving over someone's field. You may cause significant damage to irrigation systems, for example, sometimes in the hundreds or thousands of dollars, but you look around, it's late at night, you don't see anybody to report to. What are you going to do? Are you just going to, scribble a note, my name is William, I was here, and stick it on the tree or a bush or something? That's not exactly how the law works. You still have a duty to find out who is the owner of the property. If you're ever confused, you report it to the police or CHP. So sometimes people leave because they don't see anyone who they feel they can report to, or the damage is done to public property. And that's an incorrect understanding of California law and hit and runs. And that results in people getting charged when they shouldn't be.
Absolutely. And then lastly, I think it's really common. You see this a lot in our practice. There are a lot of clients that we work with who have mental health issues such as anxiety, depression, panic attacks. And so you often might see it where somebody may be experiencing some anxiety or panic attack, and they may even briefly leave the scene, and then all of a sudden they're facing criminal charges for that quick departure to deal with their own mental health issue, and they left the scene.
Even if they come back, it's still considered to be a hit and run.
Exactly. I think that's something that not a lot of people may realize when it comes to the law here.
In the first example that we gave you, we talked about a general misunderstanding of California law when it comes to drivers who are involved in accidents. And so to help you understand exactly what you are required to do, Ms. Wilson and I will give you a very brief summary of California law that applies to drivers involved in any kind of accident, whether or not they are at fault for it. So, number one, these legal duties only apply if you're actually a driver, if you have been involved in an accident, and it is known to you, or should have been known to you from the nature and circumstances of that accident, that this accident resulted in either property damage or bodily injury. If the accident was so minor that it would not have appeared to a normal, reasonable, average person that any kind of damage or injury arose, then there is no duty to report this accident. But you have to be very, very careful, because if the police, if the district attorney, and ultimately your judge or jury disagree, and they believe that from this set of facts, any driver should have known that someone was likely injured or some property was damaged, you might be on a hook for hit and run. So you have to be driving, you have to be involved in an accident, and you have to know actually or constructively that this accident resulted in either bodily injury or property damage. Now, Alana, most of us understand that if we are involved in an accident with another car, for example, we have to stop by and give them a copy of our insurance. But that's not quite how the law reads, correct?
Correct.
So what are your primary duties as a driver in the state of California? What's the very first thing you need to do?
The first thing you need to do, stop immediately.
You have to check to see if anybody is injured. You must render aid if somebody is injured. And if you fail to render aid or summon somebody to render aid, you could be liable for any worsening of that person's condition caused by your departure or failure to comply with your legal duty. You also have to immediately provide your name, your address, or in the alternative, the information for the registered owner of the car. And you can comply with those duties by either locating and giving it to that person personally, or you can leave it in an obvious place by way of a note. And then you have to notify the police or the California Highway Patrol if this happened in a remote or unincorporated area. But some of our clients get a little cute with this, Alana, and they figure, well, as long as I'm seen scribbling something on a piece of paper and, sticking it somewhere, I'm going to be okay. But I think the law figured out that some people might use it as an excuse. So the word used in the jury instruction is conspicuous. That means you have to make it obvious. You have to clearly write down this information, and you have to leave it in an obvious, conspicuous place where somebody else will see it, will find it, and be able to figure out who was involved in an accident responsible to damage for damage to their property. Okay?
Something that I find interesting, William, is that it doesn't matter whether you were the driver at fault or the driver who was hit in the hit and run. You do have a duty to stop immediately.
That is absolutely true, and it's one of those fascinating nuances of this a particular area of criminal law that most people are completely unaware of. They figure that if I am a victim of an accident, if I'm a witness to an accident, if I got somehow into this mix, but I really am not interested in suing anybody, maybe I don't have my driver license, maybe I'm driving when my license is suspended, maybe I've had some alcohol in my system, maybe I'm undocumented or have some other reason to want to keep my name off the police report, maybe I got warrants out for me. So sometimes folks leave thinking that I'm not at fault, I didn't cause this accident, I gotta go. Not true.
Absolutely. Now, William, you've tried a number of these cases and you've been rather successful in your practice trying some hit and run cases. Can you walk our viewers through what are some possible defenses to hit and run driving?
Yes, absolutely, Alana. I think there are probably a total of 5. One defense that I like to use. In cases where the accident is not really significant, we can argue that there was no obvious damage to property and the nature of the accident was such that our client did not realize that it resulted in any bodily injury or property damage. This could be an example of you reversing out of a stall in a parking lot. You thought you gently tapped somebody else's front bumper with your rear bumper. You sort of got out, you peeked over your shoulder, you didn't see any damage, and you took off. In that scenario, after you're later reported for hit and run because you're maybe seen on a security camera or the neighbor is running after you, yelling and screaming, you have a defense. And your defense is that you did not actually know or constructively should have known that you were involved in an accident that caused any kind of damage and therefore no liability for hit and run. So I like that defense. It's been successful to us in a number of cases. I also like the defense that our client has actually complied with the law. And related to that is something called a mistake of fact. In California, if you reasonably but mistakenly believe a fact, and if your conduct would have been lawful, if the facts were exactly as you believe them to be, then it's not a crime. And so if we have somebody who is either complying with their legal obligations or complying in such a way that reasonably but mistakenly led them to believe that they're complying, then there is no hit and run. So maybe they leave a note in a place where they believe it's going to be found. It's a conspicuous place. And, instead of field number 1, where irrigation was damaged, it ends up being field number 2. Or they think that a light, pole or utility pole is owned by this company and it ends up being owned by a different company and they notified the wrong one. Or perhaps they notified, owner of a business and they notified the wrong business. If the facts, as they believe them to be, would have made it lawful, then it's not a crime, it's not a hit and run. You brought up earlier in this video a dangerous situation. I love me a good necessity defense. So in some circumstances, a person may argue that it was necessary for them to leave the scene of the accident. This happens in a situation where you managed to hit a vehicle or a person or maybe a motorcycle or a bicycle, whatever the object or person happens to be, but you end up with a victim who is so aggressive, so loud, so scary that it's dangerous for you to remain at the scene. In those circumstances, you may be able to argue that it was necessary for you to do so. There is a defense of necessity, which looks at things like whether or not you created an emergency situation, whether the danger that you created by your actions was greater or lesser than the danger you avoided by leaving, whether or not you substantially contributed to this emergency, whether or not you had any lesser alternatives available. So things like that in rare circumstances, but especially where we have a really nasty driver on the other side or property owner on the other side, that could help us obtain an acquittal for a person. Then you also have a defense in limited scenarios of unconscious drivers. So if you have a driver who was knocked out as a result of an accident, and by the time they came to, they're out of compliance with the hit and run, law, there is a portion of the jury instruction that says that as soon as they regain conscience, if they come to their senses and then comply with their obligations, then quite possibly it's not a hit and run. And then we also have a really robust area where we have achieved quite a bit of success in litigation, and that has to do with a group of cases and clients you're particularly passionate about, correct?
Yes. So sometimes clients with mental health disorders qualify for a program in California called mental health diversion. In order to qualify, you do have to have a qualifying diagnosis under the DSM-5. So some of the previously mentioned diagnoses may include depression, anxiety, or panic disorder.
Which would go hand in hand with leaving the scene of the accident, frankly.
Yes, well, the second prong of mental health diversion is that there must be a nexus between the diagnosis and the facts of your crime, which here, a panic attack would go hand in hand with a hit and run. You do have to be willing and able to participate in treatment and not be a threat to public safety, which generally people who are in these scenarios tend to be
low-risk offenders.
Low risk, and
or
it
no
tends
criminal.
to be an isolated incident most of the time. It's not something you typically seek to participate in. It's something you find yourself accidentally engaged in.
And this gives you a really great opportunity, if you participate in this treatment program, to avoid a criminal conviction for a hit and run, which can be considered a crime of moral turpitude. It could result in significant professional consequences for someone. It could be a huge problem for a commercial driver, for a licensed professional, for somebody going through school and receiving financial aid, who is perhaps an undocumented immigrant or a person who is a non-citizen in this country. So mental health diversion is a terrific opportunity for a person who is guilty of a hit and run, but suffers from some kind of mental health condition that can be treated and that the person is willing to participate in treatment for. That's a really great opportunity if a person is willing to go through that program to avoid having a conviction. And then I think perhaps equally often utilized approaches are something called a civil compromise. That's where you agree to compensate the other party for their losses, and if they're willing to attest that they have been made fully whole for all of the damages caused by this hit and run. This would not necessarily work in a felony case because that statute applies to misdemeanors only. But if you have a victim in a hit and run who you have made fully whole, if they're willing to come to court or present an affidavit, swear out that they have been made fully whole for their losses, then the judge has the discretion, and oftentimes we get prosecutors to agree to it, to dismiss the case, and therefore you will not have a conviction. And then finally, there is also a program for misdemeanors only called Misdemeanor Diversion. This is for first-time offenders, and it also gives opportunity to the court to recognize when somebody has no prior criminal record, where they could suffer a collateral consequence to their professional license, to their housing, to their employment, or to their immigration status in this country, to give you some of the most common examples. And they could suspend criminal proceedings against an individual, put them on a period of supervision, impose certain terms and conditions, perhaps order restitution to be paid, doing some community service, things of that nature, and that too can result in a dismissal of the case. So all of those defenses and the creative approaches that we have discussed could provide a person with really fantastic opportunity, even though they may have left the scene of the accident, they may have totally committed a hit and run, to nonetheless save themselves from having a criminal conviction. Now, if you guys have been watching our videos, you know that at the end of almost every video, our attorneys love to bring to you a helpful list of tips and tricks, things you can do if you or someone you cared about were involved in a situation like this and you're trying to stay out of trouble. So here you go. Alana, take us to number 1.
Never, ever call the police to report your vehicle stolen.
That's a horrible idea. Why would you do that? People do it all the time. It's crazy. They figure we've been involved in an accident, car is left at the scene, nobody has seen us, let's report that somebody stole the car. But that leads to bigger problems, doesn't it?
Absolutely.
In fact, what we often see is that this exact scenario could lead to significant charges, not only for you, but for other people in your family involved, including felony charges, charges of conspiracy. It could involve charges of making a false police report. And almost every time when we later pick up this case, we go to court, we try to resolve it, we try to settle it, we see much higher sentences, much greater liability, and the need for much greater accountability from judges and prosecutors. So don't do it. Number 2. Don't call your insurance company or go online to file a false police report. That's even worse. That's a felony. If you file a materially false claim with your insurance company in order to get compensation for the damages caused to your vehicle, you're going to be looking at a felony charge. So don't do that.
Don't lie about what happened. You have a right to remain silent.
It's so much better to just not say something as opposed to saying something that's not true, shooting down your credibility and incriminating yourself in a process. Related to that, once you have already committed the crime of hit and run by leaving the scene of the accident, please don't go back to the scene to do your own investigation. Most likely, you're going to get stopped, detained, questioned, or arrested. Or even if you manage to not do that, you're just going to provide additional evidence that you and not someone else was the driver. Even if your car is left at the scene, the police officers may be able to connect you to the car, but remember, they always have to prove that the person they are investigating is actually the one who drove the vehicle and thereafter failed to comply with duties as the driver. If they don't know that you specifically drove the vehicle, they cannot pin this hit and run on you, and they may be left with an open case that they cannot close. So don't help them close the case. Don't provide them any additional evidence for free. Be smart and stay out of trouble.
Now this one can be tricky, but you have to remember that you have a duty to cooperate with your insurance company, or you risk losing coverage with them.
That's a really good one, Alana. I think so many people don't realize that when you sign up for an insurance policy and you get that very long list of terms and conditions, one of those conditions in fine print basically says that if you are ever involved in a car accident, you have a duty to tell them what happened, to answer their questions and cooperate. And failure to do that can void coverage, and that means you could be on a hook for that $35,000 car with gap insurance. This one may seem obvious. Please don't get your loved ones in trouble with conspiracy charges or charges of being accessories after the fact. I know that getting involved in a car accident is scary. I know that sometimes people make mistakes and they leave their car at the scene of the accident. Please remember, if you come home and you get your mom, your dad, your grandma, your uncle, your boyfriend, your girlfriend, or your very close friend involved in helping you cover up the crime, park the car in your garage, fix up the damage to your vehicle, or lie for you, you're exposing not only yourself for additional liability as a conspirator, but you could create liability for that other person you really did not mean to expose to liability as either an aider and abettor, an accessory after the fact, or a fellow co-conspirator in this crime.
And of course, the first thing I think you should do, get an attorney immediately.
Make sure you have an attorney who practices in criminal defense. Make sure this is an experienced lawyer who is able to walk you through the scenario and has handled that scenario previously. This is not a time for you to call your friend's friend who may practice landlord-tenant law. It's not the time for you to call somebody who you know may have done some immigration law or family law. This is a situation that calls for a specialist, situation that calls for somebody who handles these exact scenarios all the time. And if you follow these tips, if you follow these helpful suggestions, we're confident that you will be able to improve your legal situation and stay out of trouble. Thank you very much. We really hope you like this video. Please click like, please subscribe, and come back to see us soon. Thank you.